Yes, Ms Stacey, I think we can start.
My Lords, I appear for the appellants on this appeal, and Mr Foster appears for the respondents. My Lords, you will have gathered from the statement of case which is filed on behalf of the appellants, and indeed that filed on behalf of the respondents, that this appeal arises out of a claim to an equitable interest in an undivided half share of land in St Lucia, based on the doctrine of proprietary estoppel. The claim is based on promises made by the previous owner of the land, Mrs Geraldine Pierre, who is now deceased, and acts undertaken by the respondents in reliance on that promise.
Yeah.
The land was sold to the first appellant in 1999 for consideration, and the second appellant is the owner of the other half share, which is not the subject of this current dispute. My Lords, if I may draw out one point at the outset, before giving your Lordships an outline of where I propose, with your leave to go in my oral submissions. Our starting point is that this appeal is concerned with a legal issue, a point of law, namely whether the Court of Appeal were right to hold that the judge erred in law in his approach to the question of whether a proprietary estoppel arose by having taken account of countervailing benefits found to have been enjoyed by the respondents over the years. We submit that is the primary question on this appeal. The judge made findings of fact that valuable benefits had been enjoyed by the respondent over a number of years, 30 years, and continued to be enjoyed, in the words of the judge, until this day, that is to say, at the date of judgment. And having regard to those, and based on the evidence that was before the judge at the time, he found that no detriment had been suffered by the respondent. And my Lords, whilst the respondent appealed to the Court of Appeal on the facts, and you may have gathered from the grounds of appeal before the Court of Appeal that effectively what was being said at that time was that that finding was against the weight of the evidence. The Court of Appeal allowed the appeal not on the facts, but on the basis that the judge made an error of law. We submit that the trial judge made no error of law for reasons I will expand upon in due course. And if that's right, then the basis upon which the Court of Appeal allowed the appeal falls away. Now, your Lordships will of course be familiar with the requirements of proprietary estoppel.
Yes, we don't need very much by way of authority. You've been very thorough in your written case, if I may say so.
Yes.
And the law is really very familiar.
And indeed, I don't believe there's much between my learned friend, having read his case, and I, as to the applicable principles.
I don't think so. I gathered from Mr Foster's case that he's really interested in the facts rather than the way they should be looked at.
Yes. I mean, the reference is made to Cobb and Yeoman's Row and the distinction between a domestic and a commercial case, but I don't understand it to be being said that the components differ depending on what kind of case is before a court. Yeah. With that in mind, then, my Lords, I've handed up a document, if I could invite your attention to that. It's effectively an outline of the submissions that I make in my case.
Yes.
And which may or may not be helpful to be expanded upon in oral submissions. The submissions in that document effectively follow the same order as the grounds of appeal as they appear in the statement of facts and issues which aren't agreed, yes. And the written case at paragraph 2.
They're said, described as unagreed, but
it's unagreed.
There's not a great deal of differences. I mean, the material in it seemed to me not controversial.
No, I believe it was unagreed simply for administrative reasons. Timing dictated that Mr Foster wasn't in a position to agree it at the time.
Right.
I haven't had an opportunity to ask what's between us on that document, but your Lordships will see that the submissions are essentially divided into two essential categories. The first two relate to the question of whether an equity arose at all, which raise the questions of detriment and unconscionability. My Lords, the submissions in relation to unconscionability overlap necessarily, because the doctrine of proprietary estoppel can't be subdivided into watertight compartments, and there is therefore a necessary overlap, and I apologise for any repetition in my case. Unconscionability involves consideration of the extent of the detriment, and our submissions in relation to that deal with detriment, but they also go on to consider the effect of any equity on the conscience of my first appellant client as a third-party purchaser for value. And what we submit in relation to that is that the issue of unconscionability needs to be considered de novo as against her at the time the land was sold to her.
Is there any authority then? I mean, the judge at first instance actually found as his most compelling reason the fact that your client was a person of value, but in fact, that's gone out of the window. I mean, you, as I understand it, you accept the Court of Appeal's judgment that, in the light of the legislation, was simply not a good point.
Yes.
But now you come back to this paragraph 2C of your print of this, to my mind, extremely helpful outline oral submission piece of paper you just put before us. And you say that somehow the fact that there was a sale and your client acquired it puts a different complexion on that question.
No, not so much a different complexion, simply this, that the issue of unconscionability wasn't considered by the trial judge because he found at the first hurdle, namely that of detriment, that the claim wasn't made out. He didn't go on to consider what would have happened next, namely the question of unconscionability, nor was that considered by the Court of Appeal. And there is authority in Gray to suggest, to which I'll take your lordship in a moment if I may, to suggest that given that the doctrine of proprietary estoppel is founded on this overarching requirement of conscience, if the land has been sold to a third party, one needs to consider the matter in the rounds to whether or not the requirement of unconscionability is satisfied. And one can't, therefore, we submit, look at that without having regard to the first appellant's particular circumstances, given that she has, subsequent to the promise, acquired the land.
Who are you looking at when you test the matter, and at what date? And do not look at the back to Geraldine's actions, whether it was unconscionable for her to enter into the transaction of sale.
Yes, one needs to consider the matter as to whether or not it would be unconscionable for Geraldine Pierre to renege on the promise at the time she did. That would be in 1999.
Yes.
At the time of the sale.
At the time of the sale, yes. But it might be helpful at this time to refer.
The end of that, because I mean the court is making a decision now. Let us suppose that Geraldine had, subsequent to the sale to your client, recognised that she'd committed an injustice or something that might be regarded as an injustice, and had left Mr. Calixtus Henry a substitute sum of money or property in her will, making clear that this is compensation redress. That would no doubt come into the balance as an element of the decision on conscience.
Indeed it would. One needs to, it's really Lord Walker in Gillette and Holt when he said one needs to look at matters in the round. It's given that the purpose of the equitable intervention, interference with strict legal rights, is based on the doctrine, is based effectively on whether or not it's unconscionable for the promise not to be made good, then one needs to look at all factors, including not only the reneging of the promise in 1999, but also the circumstances of the claimant at the time the claim is sought to be made out, including any third party or subsequent dealings with the land.
Does it affect the remedy? Because obviously the third party is affected by the remedy, and one might say that the remedy that the Court of Appeal had in mind here was rather extravagant.
Yes.
And one would consider whether it was right that it should be as far-reaching as their order made it.
Yes.
Does one, when looking at things around, extends the remedy as well as the route by which you reach the question of remedy, does it?
Well, what I say about that, my lord, is that it affects unconscionability. But if you're against, if the court is satisfied that it is nevertheless having regard and balancing the interests of the parties that are before the court, unconscionable for the promise not to be given effect to, so as to raise an equity, then one goes on to the question of relief, and we will further submit at that stage that one needs to consider the balance of the interests of the parties when considering and fashioning the appropriate relief to give effect to the equity.
I follow that.
And indeed the extent of the equity, because you've gathered from my statement of case that our primary position on relief is that the equity has been satisfied by reference to the benefits that have been enjoyed.
Well, one of the things which strikes one, and this may be rather more factual than you wish to be, but there's just so little information about the site. We haven't got, we've just got one plan, we haven't got any photograph, we haven't really got any idea what this building is that Mr. Calixtus Henry is supposed to have lived in, or where it is.
No. It's been described as a wooden house. We know that. We know nothing about how much it cost to erect it. We know nothing about its size. We know the size of the land. We know it's a large land. That comes out both in, we've got the hectare, so the square footage, and we've also got a comment in evidence where Mr. Henry accepted it was a large area of land.
7.81 acres.
Yes.
Yes.
8.1
Well, well, 7.81 was what I
It's in the statement of facts and issues, I believe, where
The plan on page 268
right.
gives precise hectareage and acreage of 8.1 acres.
Oh,
It's not going to make
Yeah.
much difference. But my impression was that part of it is extending up the mountain.
Yes, it is.
So I take it it's quite precipitous in parts, at least.
Well, I haven't had the good fortune of going there.
Which have a view.
Yes, well, I did try and push for that, but I wasn't given the indulgence. But my lord, you're right. There is a lack of information as to precisely what this land is. We know it's farmland. We know that produce was grown on it, and that the respondent benefited from the produce in terms of feeding his family.
We don't know how much of the land is farmland, do we?
We don't know.
And how many structures were there on that?
My understanding was that there was one structure, but that's in dispute. And so far as your lordships will allow further evidence or the evidence to be explored and investigated, it was the position of the respondents that a further house was built subsequent to the house having been built by the grandmother in which Mr. Henry lived.
Well, he
from
said that
birth.
in his statement of claim.
He says that in
But
his
it wasn't,
statement. of claim.
as far as I could see in his written statement, his witness statement, I didn't see that. And
There is
the
one,
judge
to
hasn't
be
made
fair
a
to the
finding.
respondent, there is one reference in the witness statement to that. In the pleading, in the witness statement of paragraph 17 on page 12 of the record,
Yeah.
it's buried pretty deep.
Oh, I'm so sorry. Yes, at paragraph 17, I built my house.
I built my house on the land. But, my lords, I'd invite your lordship's attention to the fact that there was no evidence as to when. There was no evidence from the respondents as to how much it cost, what the structure was, the circumstances in which it was
None
built.
of these points were really investigated by us.
Well, my client's witness statements were contrary to that. They simply said that it was the references are in the first appellant's witness statement of paragraph 20 on page 21.
Sorry, which
Page
page?
21. Paragraph 20, where it's said that Calixtus came to live on the land, and that was effectively in the grandmother's house. And then at page 23, we have the second appellant's statement. At paragraph 3,
Yes,
she deals with the erection of the grandmother's house.
yes.
And then in the transcript, at page 75, we have some evidence from the respondent in cross-examination, lines 6 through to 8, where he says he was at his grandmother's home, and that was at the age of 14. Bearing in mind that his evidence was he was farming the land and caring since the age of 8. So this is supporting the fact he was living in his grandmother's house, not in any other property. And then we finally have page 166. It starts at line 19. Where the question is, but Calixtus Henry's mother lived on the land, and the answer is Gladys Henry, that's the grandmother, on the land, the house Gladys Henry, and then it peters out. It's a bit vague, but that's the sum total of the evidence about the properties on the land.
Yeah.
And the judge, you will have noted, in paragraph 3 of his judgment, at page 217. Yes, thank you. He said that the claimant was permitted to put up a wooden house. The claimant lived there with his grandmother until her death. He continues to live there until today.
Did you say paragraph 3?
Paragraph 2. I'm so sorry.
Yes. Yes.
And that's important, we say, because the acts of
Is there a finding of fact?
it's not under the heading, the facts, which is to be found on the following page.
Well, it's the background, these are all facts.
These are all facts, and we would say yes. Because the evidence was there was conflicting evidence about the point, and this is the judge's conclusion on it.
What he doesn't say is that, the respondent put up a house.
No,
So there's no finding.
no, there's no
mention
finding
of
of
that at
fact to
all,
that.
actually.
No. And we would say the inference from that is that evidence was rejected.
Well, on the other hand, there was no cross-examination, was there, to challenge the statement in paragraph 17?
There wasn't, no. But the witness statements of the defendant's witness statements put a different position, and nor were they cross-examined.
Yeah.
Can I just, going back to the point about the effect on the first defendant, or the sorry, of the sale, and whether one looks as a separate test of unconscionability. Whose conscience is the relevant conscience to look at?
Well, according to Gray, the editors of Gray, it's the conscience of the third-party purchaser.
So does that mean you can never, if the third-party purchaser is a bona fide purchaser of value without notice, is the law that the equity can never operate?
I don't go so far as
If
to,
not, why not?
I don't go so far as to say that. I think it depends on all the circumstances. If, for example, the detriment suffered by the relevant claimant was such that it would be a travesty of justice, if you like, to deprive him of his right, and if it might be said that there were facts that would have made it known to the third-party purchaser that there may be an interest. But if one looks at Gray, it seems, the editors of Gray seem to suggest that one needs to consider at least the circumstances in which the land was transferred and the issue of conscience as against the purchaser themselves.
Why or put it this way, is the purchaser not affected by section 28 of the statute? Yes. Because, I mean, the purchaser's first inquiry should be, is there anybody in actual occupation?
Yes.
And on the facts we're given, the answer to that would certainly be yes.
Yes.
That would be perfectly obvious if she
Yes.
went there. And then the question is, well, what right is he to be there? Now, there's no indication that those inquiries were ever made.
No.
So it's not without notice, it's with notice for the purposes of section 28.
Yes, for the purposes of section 28 it is. But it's section 28 relates to the interest of a person in actual occupation of the
Right,
land.
so why should he be any worse off following such a purchase than before it? Which is what your submission amounts to saying, that he's got a weaker case after this sale than before it. But why, in the light of section 28, should that be so?
Because what we say about that is that section 28 deals with the situation once the interest has been acquired. Unconscionability comes in at an earlier stage, and the absence of unconscionability would prevent the interest from arising at all.
What would be the position if there is a conscience, if there is an effort? What would then the position then between the vendor and the purchaser?
Then we say that section 28 would kick in. You'd have an interest and a purchaser, and they would be capable of being overriding the subsequent sale. So the wording of section 2 is the interest, and the role of conscience, or unconscionability, if you like, is a necessary component. In the words of Lord Walker and Cobb, it's a unifying concept. It draws the discrete elements together, and in the absence of that, the equity doesn't arise in the first place. There is no interest for the purposes of section 28. It might be helpful to your lordship if I can just refer you to how the editors of Gray put it, to see if there's if that may be of use to you. If I can invite your lordship's attention to tab, it's been Authorities Bundle 3, behind tab 37, at paragraph 9 to 93.
Sorry, paragraph what?
Paragraph 9 to 93. It's on the second page at the bottom paragraph. Starting the Land
So
Registration
it's
Act.
paragraph 13003, page 729, paragraph 3.
Page 1238.
Oh, are we looking at the right thing? I'm looking at page 729.
Page 1, 2, what, tab that, sorry, I'm so sorry, it's tab 38, I'm so sorry, my lord, and it's at page 1238.
That makes a difference. Can you just beg your pardon, the page number again?
Yes, I'll do it by reference to the page numbering. 1238.
Yes.
We have no frontispiece. What is this piece of paper?
This is Gray's Elements of Land Law. It's the most recent edition.
Don't you normally give us a frontispiece?
Wow. And we're looking at paragraph 9.2.93.
9.2.93, and it starts off by referring to the Land Registration Act.
Yes.
It's dealing with the question of whether the burden of an equity passes to a third party. And the Land Registration Act has finally placed the proprietary character beyond all dispute. It's, the equity arises as an interest capable of binding successors in title, and that comes from section 116, which is referred to in the footnote over the page. And then, my lords, after the footnote 2, just about halfway down that paragraph, it's the extract starting, of course, the mere fact.
So third parties have a burden they must discharge.
Third parties must discharge the burden of showing that their proposed assertion of strict legal entitlement is not in its own turn unconscionable. The call of conscience requires to be measured de novo in the light of the circumstances in which each disponee takes title.
Yes.
The ultimate effect is tailored specifically in the discretion. Then it says, the mere fact that an equity of estoppel might command a particular remedial outcome against one estate owner is in no way precludes the possibility that another remains free without injury to conscience to enforce his strict legal rights.
I mean, I suppose that might apply where, for example, inquiry is made of the person in actual occupation and a misleading or perhaps dishonest answer is given.
Maybe.
So that's the kind of case where you would then have to consider the position
Yes.
of the person who perfectly properly inquired.
Yes. Yes. But the suggestion from this, at least, come back to my Lord Hope's question about whether it comes in at the stage of an equity arising or whether it comes at the stage of relief. This at least seems to suggest that it comes in at the stage considering whether or not it binds the third party. So it has arisen, but does it arise? Does it affect? Does it continue to exist?
Yes.
So far as the third party is concerned.
But where can we go on this chapter? Because the trial judge hasn't made any findings, has he, about inquiries being made?
No.
I'm not sure that was really an issue at the trial.
No, it wasn't an issue. He did say, however, in his judgment, it's a point. It's not one of my primary points, but it's a point. It's a nuance on the issue of conscionability, and given that my client is the first appellant is a third-party purchaser, and given this, it seems to indicate that rather complicates the issue of whether or not the test of unconscionability has been satisfied. It's a point I feel that ought to be made, particularly in circumstances where the issue of unconscionability wasn't considered either by the trial judge or by the Court of Appeal. Altogether. Yeah. The issue of unconscionability is quite. But it comes in, we say, at this stage. If I'm wrong on the first point, which is that the judge was right to find no detriment and was entitled so to find on the evidence before him, and there are no grounds for interfering with that, and indeed the grounds upon which the Court of Appeal interfered were misconceived, then we don't get to this point. But if I'm wrong about that first point, then one needs to then consider this second stage. And this second stage involves consideration of points raised at stage one, namely the extent of the detriment and countervailing benefits, but it, in addition, also involves considering the position of the third-party purchaser. My Lord...
that would be, wouldn't it, on analysis, that would be a separate inquiry, wouldn't it? I mean, the one thing is the unconscionability of the original disposition by the disponent, the old lady in this case. But then if you're going to say, and nobody said it yet, but if you're going to say that there was particular circumstances surrounding the disposition from your client's point of view, first appellant's point of view, which in effect raise a question of conscionability in relation to those particular facts, then you would, if this is correct, you would then be in a position to attempt to discharge the burden imposed on you by the Land Registration Act, which says that you take subject to the rights of the, in this case, the respondent.
That's right. That would need to be...
But that has never been ventilated at all.
No. And indeed, before one even gets to that stage, given that unconscionability wasn't considered either by the trial judge or by the Court of Appeal, what the respondent would need to do would be to satisfy the court that it was unconscionable as against the deceased, first and foremost, to renege. So even before one gets to the stage of considering the conscience of the first appellant, one needs to circumvent that first hurdle. So there are a number of... I'm bringing this to your Lordship's attention as an indication of the hurdles which would need to be surmounted.
Was no question of unconscionability discussed at all?
No. Because the judge was... Written submissions were... Sorry, before I say that, I think it's right and fair to say that the defendants made their submissions orally and that they're in the transcript. But the claimant, the respondent, made their submissions in writing. A number of authorities referred to the trial judge, which dealt with the question of unconscionability, and they're referred to, I believe, in my statement of case, the authorities that the trial judge was taken to. And that's in marked contrast to, in fact, it's in the Statement of Facts and Issues.
What?
In the Statement of Facts and Issues, I think there's a, yes, paragraph 12.
Yes.
So the trial judge did have the benefit of those authorities which deal with the issue of unconscionability. That's in marked contrast, of course, to the Court of Appeal, who didn't have the benefit of reference to any authority.
But my impression on looking at the defence at pages 6 and 7 is that the issue wasn't raised.
No.
And it doesn't seem to have been raised in the written submissions, which end at page 38. Mr. Al-Seed doesn't seem to have raised it in writing, at least. So it's not surprising the trial judge didn't really focus on the point.
Yes, I accept that. There was no specific argument on the issue of unconscionability.
Well, would you like to concentrate on stage 1 then, and let's see if where you stand on that, and we can come back to stage 2 in the right order.
My lords, you indicated that you're familiar and you don't necessarily need me to take you through the requirements of proprietary estoppel. For your notes, your lordship's note, can I invite your attention to certain convenience reference points? Certain convenient reference points.
Yes.
The summary of the essential elements are at tab 3, bundle 3 at tab 37 on the first page. That's in the Gary-and-Wade.
Yeah.
And then in grey, bundle 3, tab 38, paragraph 922 and 928.
Sorry, paragraphs?
922 and 928.
Yep.
I'd also invite attention to the judgment of Lord Scott in Thorner and Curtis, and that's in bundle 1 at tab 13.
That's the recent case.
Yes, that's the Farmer case in the House of Lords. Bundle 1, tab 13, paragraph 15, where he says that all three elements are always necessary but not necessarily sufficient of themselves.
I think you give the quotations
Yes.
in your written case, don't you?
And then I do, yes. It's paragraph 19.
Paragraph?
Paragraph 19 of my written case. The elements are reconfirmed by Lord Walker and Scott in Cobb and Yeoman's Row, and that's bundle 3, tab 35, at paragraphs 46 47, and 92 deals specifically with the issue of conscience, where Lord Walker considers whether or not it's a fourth wheel on the cart, if you like, a requirement of its own, and he appears to form the conclusion that it is a unifying component. And if the result doesn't shock the conscience of the court, he says, then it needs to be looked at again. And I also refer to that in my written case at paragraph 25.
25?
Yes.
Yes.
And finally, my lords, to the judgment of Lord Walker in Gillette and Holt, and that's at bundle 1, tab 10. At pages 225.
This is your point of paragraph 26.
And that's my point. That's a point that comes out from the extract, but there are at page 225 C2E, and indeed there's a reference to Taylor's fashion. It's the point about no watertight compartments, and it's also the point about the detriment needs to be substantial.
Yes, I mean, Lord Walker makes this point in quite a number of cases.
Yes, indeed.
Paragraph 47 of your case and
Yeah.
Datec, he's making the same point, that in practice these things tend to run into each other.
Indeed, indeed. And at page 229 of Gillette and Holt, he says he makes the point that it's the detrimental reliance on the promise that makes the promise irrevocable, really underscoring the importance of that element.
I see, yes.
And then he goes on at 232 to consider detriment in more specific terms.
Yes. The way
So-
he puts it rather tends to focus on stage one, doesn't he? If the promise is irrevocable, you're looking at the promisee, or promisor rather,
Yes.
at the deceased, and asking whether it really
Yeah.
was proper for her to dispose of the land to the third party.
Yes, although of course in that case there wasn't a third party, so the issue wasn't, the issue which is raised, or the subtlety that was raised in this case wasn't an issue before.
Yes.
But so far as my stage one is concerned, and if we're looking at Gillette and Holt, I suppose I focus on page 232, where he deals with the issue of detriment in more specific terms. And I think it's appropriate at this stage to refer your lordships to Greasley and Cook, which is a case specifically relied on and referred to by the respondent. And it's dealt with by Lord Walker in Gillette and Holt at page 232. The respondent refers to the judgment of Denning in Greasley and Cook, and a passage which might be taken as suggesting that any action in reliance on an assurance would be sufficient to give rise to an equity. That passages can be found in the first volume at tab 5. At page 713. It's just under letter F, where he says the second point. Running down to the reference to Moorgate and Twitchings.
Yes.
The words, I do not, it is said that A must have incurred expenditure or otherwise have prejudiced himself. Emphasise those words.
This is all explained by Lord Justice Robert Walker on page 232.
Indeed, it's explained by Lord Justice Robert Walker at 232. It's also explained in Watson's story, and it's also explained by my Lord Parker in Coombs and Smith.
That's one explanation to that.
Yes, but insofar as that is a proposition that's being put before your lordships, we would submit it's misconceived. There is no presumption of detriment, and reliance and detriment need to be, can't be equated as one. They need to be separately considered, and that comes from Stereo and Hutchinson, bundle 3, tab 31, where Lord Justice Mummery warned against equating the presence of detriment with that of reliance.
Yes.
It's tab 31 at D21. My Lord, as I indicated before, there therefore doesn't seem to be much between my learned friend and I. Detriment is an essential concept. It needs to be substantial. The underpinning requirement is that of conscience. It must be judged at the time of revocation, and it must be pleaded and proved. It is also clear from the authorities that, as a matter of principle, regard should, not only can, but should be had to countervailing advantages, namely the approach taken by the trial judge. And the reference points for that proposition are numerous, but if I can invite your Lordship's attention to a number of them. McGarry and Wade, tab 37, in the third bundle at paragraph 13016.
What's the reference again? McGarry, wait, what page?
13016.
Yes.
Gray and Gray, tab 38, at page 1230. That's dealt with under the heading counterbalancing advantages. In the section, your Lords will note from the, if you flip back a page, it's the section entitled Unconscionable Disadvantage or Detriment. Yeah, you refer to a number of authorities.
If you improve your house, but you're entitled, you're living there rent-free, there's a sort of balance of advantage. You might have had to pay rent if it had been strictly dealt with. Yes. And that's to be balanced against the expenditure on the improvements.
It's a balancing exercise, yes. And what one's searching for is whether or not when one puts it all in the pot and swishes it around, whether there's any net detriment. And that's a matter of impression for the trial judge. It's an inference that he draws from the fact. I suppose it's a mixed question of fact and law. The finding made by the judge was, we say, first and foremost, a finding of fact based on the evidence before him. So that's Gray and Gray. Then we have the judgment of Lord Justice Dunn in Watson's Story, which is at bundle 2 at tab 18. And I would invite your Lordship's attention to the passage. It's in the second column, where it's probably about 15 lines up from the bottom, where he says, in considering what detriment had been suffered by the defendant, regard had to be had to the countervailing benefits that he had received, namely the occupation of a rent-free house of which he was very fond, and the benefits he did receive under his grandmother's will.
So what would the fact say? He gave up the tenancy of his home in Leeds. Look at the third line.
Yes.
And the prospects of finding employment there. So he effectively moved to Nottinghamshire.
That was a change of position, a clear change of position.
Yes, and his girlfriend went down there too, and then
his girlfriend gave up her job.
Yes.
And he remained in. Very short term. Yes. But there was it suggested, I think the respondent seeks to suggest in the case that there's an inference that he must have given up opportunities that would otherwise have been available to him. That comes in the respondent's case. But there was no evidence to that effect. There was no evidence of a change of position.
Well, one does, on the other hand, take from the evidence this, that he effectively committed himself, just located himself there as a place where he was going to live for the foreseeable future. And, I mean, one can see that it's not just a matter of balancing expenditure against profit. His whole life was situated on this piece of land. And indeed, we see he remained there after she died, and the whole thing speaks for itself in a way that this became his home.
It did become his home, but there's no suggestion that he was born there. He had a relationship with her. He was a farmer, and there is no specific allegation that he did give up any other opportunity. So it would be open to the court to take the view that he did well. He was there, he was living there rent-free, but it suited him to be there.
But you might say it never crossed my mind that I'd have to think of other opportunities, because I knew I was going to be here because she'd promised me that I would have the ability to stay. So,
but the detriment needs to be pleaded and proved. And the editors of Gray in certain other cases... the detriment was specifically asserted, and if it hadn't been asserted, the case wouldn't have presumably got off the ground. But it was put in a certain way, namely acts of caring, working the land, building the house.
yes.
Those were the 3 acts of detriment. No, I gave up an opportunity to live elsewhere. And in Gray and certainly in a number of other cases, detriment is referred to as a change of position.
One respect in which his whole life wasn't focused on the land, which you haven't mentioned. He said that economically, the farming was a sort of bonus insofar as he said, all the money to keep himself and his family was coming from working as a baker.
Baker, yes, he was a baker.
That may raise the question whether a finding that he requires the land in order to live would be correct. It seems to be saying no. This is sold the fruit, produce when he was on the surface, but now he's living as a baker.
Yes, I don't think there was a finding that he required the land in order to live. The finding was rather...
That would raise the question,
Yeah.
If
No.
one says that his whole land was focused on this and he was a farmer,
Yeah.
that suggests that he needed it.
Indeed.
I don't think he was saying.
Well,
No,
I'm
he
not
wasn't.
sure. I'm looking at the judge, paragraph 12,
Yeah.
page 219, second last line. He testified that this had been the source of his livelihood in large measure.
In large measure.
Now, I quite see the bakery business would be the other side of it, but that seemed to be his evidence. And the judge hasn't pursued this in his findings, of course, but
No.
that's what we seem to...
His evidence was that he did, certainly in terms of sustenance farming, he fed his family from the produce of the land.
Yes.
And the point I'd like to make at that stage is that what amounts to a benefit is necessarily context specific. So being able to sustain oneself and one family from the products of a land may be regarded as less substantial a benefit depending on the environment in which one finds oneself. But the judge, based in St Lucia, plainly considered that was a substantial benefit. But in addition to that, he also was able to sell produce which was in surplus to that which he was able to feed his family. I accept that there's no specific evidence as to how much money he made from that or indeed how much surplus there was, but there was evidence that there was surplus, and it wasn't ever suggested that anyone else benefited from that. My Lord Mance refers to the fact that he was a baker. There is some evidence to that effect, and indeed it's quoted in the respondent's case, which rather suggests that he wasn't focused entirely on the land and didn't need it.
It's really more, the flavour I get is this is where he lived.
This is where he
And
lived.
of course he had a variety of other things, no doubt, he was doing around the place. But it's the permanence that he is, I think, saying that he was entitled to assume he had, that this was the place where he was living and would be able to go on living, and the thought of moving anywhere else just didn't arise.
No. Well, that's an assumption he may have made, but question whether or not that particular set of circumstances, bearing in mind the advantages, gives rise to an interest which would supplant that of the legal owner, is a very different question.
Well, we're not at the legal owner stage, at stage
No.
one, are we? So we're still looking into the mind of the deceased,
Yeah.
and whether it was unconscionable for her, having seen what was happening, him still being there and doing what he did day by day, whether it was unconscionable for her to enter into the deed of sale.
Well, what we say about that is when one looks, one might say that there is a certain amount of detriment, but that we say is outweighed by the very substantial benefits that have been received over the years by him. Had he, for example, had to live elsewhere, one can presume he would have had to pay, he would have had to expend money on another property, other opportunities. He would have had to devote himself to his occupation as a baker in rather more laborious terms. And those advantages and benefits which the judge found, the judge was entitled to find outweighed the other side of the coin, namely the prejudice. And that is a finding. It's a sensitive balancing exercise. As I say, the extent of the benefits are context sensitive, and there is no indication from the judgment, although I accept the judgment could be rather more expansive in places, but there is no indication the judge failed to take account of relevant factors. Indeed, if one looks at the approach adopted by the Court of Appeal, that's a very different matter. The Court of Appeal solely focused on the detrimental, the one side of the coin, without looking at the other, namely the benefits. It was the judge who adopted the right approach, and we say it's not appropriate at this stage to interfere with that finding.
There is some suggestion of a disadvantage, if I'm going to put it that way, in paragraph 6 of his witness statement. It's page 9 in the bundle. And there are no findings about this, but he says there that Mamma gave everyone the opportunity to possess land on the mountain if they worked the land and cared for her, etc. Other relations, or at least one of them, attempted to do it, didn't care for it, and left. And the rest of them went to Saint-Croix and all have homes and jobs in Saint-Croix. Now, he doesn't enlarge on it at all, but there is at least a suggestion there that he was the one who stuck it out, whereas the others didn't.
There was no evidence from the others that there may have been a number of reasons for why they left. Yes, that is a suggestion. It's also a point that's raised in the respondent's case, and emphasis is sought to be placed on that as effectively tipping the balance in favour of detriment as opposed to benefit. And that's really the exercise we're conducting here.
Was there any cross-examination directed to that point? So the witness statement was tabled, in effect, wasn't it, at the beginning of the trial?
Yes.
And then they proceeded directly into cross.
Yes. There wasn't any specific cross-examination as to the reasons why people left the land or whether they would have otherwise left, irrespective. No.
As a matter of fact, more of interest, what would happen under the present judgment? Obviously, you've got only a half share. He's never suggested that he hinged upon the half share of the second appellant. So would the property actually be partitioned, or would it be sold, and is its value therefore purely monetary?
Value, as I understand it, I might have to seek instructions on this point. I apologise for not being able to give you an answer off the top of my head, but my understanding is it's an undivided half share.
Yes.
And it's treated as a whole.
It could be partitioned.
But it
applies to the court to partition it, and that's feasible, we have to do.
whether it's feasible, I don't
Otherwise, it must be sold, so he'll be off the property anyway.
Yes, yes. It's the point really that I make, well, it comes in again under balancing unconscionability, I suppose, because there is also the position, we've talked about the position, and I'm conscious I'm going from stage 1 to stage 2, but we've talked about the position of the first appellant as a third-party purchaser, but there's also the position of the second appellant as an owner of, or as a co-owner of the land. And she may not want to sell the property. No. She might want to live there or coexist happily or have it there and let it appreciate in value.
The position is any co-owner can insist on a division.
Yeah. Yeah. Mm-hmm. But there is that additional complication, which is a factor which the court should take into account in considering whether it's right and appropriate for a party to whom a promise was at one time made and who has enjoyed advantages since the promise was made, should supplant the legal entitlements of the landowner at the expense of other parties.
Yes.
My attention is drawn to the fact that in the last will and testament of the deceased, at page 263 of the bundle, a different address is given for the respondent.
Sorry, I didn't
Paragraph 3, page
263, yeah.
263. You'll see paragraph 3. It says, I name and appoint Church Street, Soufriere, St. Lucia to be executor of my will.
So how does that help?
It's just suggested, I think the suggestion that's being made is he may well live somewhere else and may not live on the land.
Sorry, you're dropping your voice.
Sorry, I'm so sorry. He may well have another property, a different address is being given for him.
This is the house at Sophia.
It's a bit speculative, there wasn't
Yeah,
any
well,
cross-examination
no.
to that effect.
It may no longer be there.
I think I was at countervailing benefits and I was taking your lordships to the authorities which support the proposition. There isn't much between us, but if I could just finish my checklist.
Yes, please.
The next authority is G&G at bundle 2, tab 27. That's authority. It's the judgment of. I seem to have lost my. I'm so sorry. I don't know.
Yes, but what's the proposition?
The proposition is that it would be wrong not to look at. It would be a travesty. I can't quite remember the wording. If you could just give me 1 moment to.
This is just take account of the benefit.
Yeah, it's to take account.
But I mean, that's really clear.
And it's clear. I just wanted to so your lordship had a full note of all the authorities relying on this.
Well, it's in paragraph 6 of your,
Yeah,
36, I should say, of your case, and you quoted the passage.
And then Powell and Benny you've got, and there are other examples at paragraph 37 of my written case.
Yes.
Well, we've dealt with how the judge approached it. We've looked at, well, if we can just look at what the Court of Appeal said about that. It's page 243, the record.
I mean, the passages where both courts look at it are extraordinarily brief. We've looked at paragraph 12
Yeah,
of the judge, and that's all there is on it.
yeah. Yeah.
And then the Court of Appeal, they turn to it at paragraph, what, 11?
11 is it's stage 1.
So there's a finding there about the detriment, but you say there's nothing about corresponding advantages
No,
at all.
they say it's clear that the trial judge misled himself into attempting to ascribe a dollar value or to compare the advantage with the detriment. On the basis of the authorities that we've been looking at, we say that's wrong.
No, it's going, I mean, you say it's clearly wrong.
It's clearly wrong, yes. And then they go on to say one doesn't buy the equity, and they make a finding that the appellant did suffer a detriment, but that finding was based on purely looking at the acts. And they go on to say that the promise was conditional on the continued working of the land. What I get from that, my lords, if I may say so, is that the Court of Appeal appear to have been treating it as a contractual arrangement. Any condition or any act is really a greasy and cook situation. Any act in reliance would give rise to sufficient detriments to allow the equity, even effectively a peppercorn consideration, and that would be sufficient.
It's the next paragraph which repeats the second sentence. There's no power in the court to say the promise and the resulting benefit is disproportionate to the detriment.
Yeah.
Yeah.
And that comes, it seems to me that comes from Jennings and Rice wasn't specifically put before the Court of Appeal, but that appears to come from the proposition that where one has an arrangement or a promise relating to a specific property, it may be easier to establish an expectation-based relief. And that's what the Court of Appeal appear to have, but they considered that there was no power to consider proportionality, and again we say that's clearly wrong.
So we've got this awkward situation that the trial judge goes wrong in paragraph 13, and the Court of Appeal goes wrong in paragraphs 11 and 12. And,
Yes, well, paragraph 13.
well, paragraph 13 is where he says, and this is quite important, the second more compelling reason is that the first offence is a purchase of a value, and he has overlooked and probably wasn't told about the provisions of section 28 of the Act. So he doesn't examine the question of inquiry.
No.
And he ticks it off as the more compelling reason for reaching the view he does.
He does. It may be that analysis, instead of looking at section 38, is a analysis of the issue of unconscionability, and that's a point I endeavoured to make in my case.
Yes.
And we say that it's possible to analyse the judge's remarks in that way, considering that nevertheless it's really a general, it's not unconscionable point.
In fact, the judge goes completely wrong in paragraph 13, doesn't he? Because purchaser for value doesn't matter. It's, he's presumably looking at the question of notice. I mean, one would have expected him to go on and say purchaser for value without notice,
Yeah.
which might have had some impact were it not for section 28 of the Act.
But it's fair to say that both reasons, whilst the second reason was considered by the judge to be more compelling, there's no doubt that the judge did find, he made a specific finding of no detriment.
Yes.
And we don't need to rely on the second reason. Indeed, we don't really rely on it. You see the way it's being put in our case. We rely on the first and say that that's a finding that was open to him. That's the only finding which the Court of Appeal specifically overturned. And they specifically overturned it on the basis that he made an error of law.
Yeah.
The background of these proceedings is slightly curious because they were brought by Calixtus Henry. At the beginning of 2006, they'd come on with what might be regarded as a dispatch. But there wasn't any counterclaim for possession or anything. Was the son, he's presumably living happily?
He's living, there was a notice to quit was given.
But that was years ago.
It was given before the proceeding, just before the proceedings were issued. You see, there's a chronology, I think, that's been handed up.
Yes, yes, there is. Yes.
And
So that's the...
you will see, effectively, what happened was that the deceased, he died in August 1999.
Yes.
That's years ago.
Yeah, and then the first appellant was registered owner in September 1999. September 99 registered owner, first appellant, after the purchase, the deed of assignment. In October 1999, on the fourth page of the chronology, the deceased dies. And then on the 19th of October, a notice to quit was sent.
It's remarkably prompt.
It was
isn't
prompt.
it, for somebody who one perhaps knew quite well that he was there. And the timing was very tight because the sale was in August 1999, wasn't it?
Yeah. She bought the land and then wanted him off it.
What's the rate of exchange between the Caribbean dollar and
I can't
roughly?
answer that. I
Roughly 10 to 1.
10, is it? Seems to me if they're 10 to 1, unless there's been a rapid...
3.76, I'm told.
Sorry? No.
3.76.
You know my lord.
3.7.
Well, throughout the whole period.
Fluctuated a bit, but there or thereabouts, I'm told.
Sorry, Miss Stacey, I couldn't quite hear. What was the
3.76, I'm told, was the rate.
3.76?
Yes. And it fluctuated, but was there or thereabouts throughout the whole period.
3.76.
3.76, yes.
To the pound?
Yes.
It's quite a valuable property.
To the pound or to the dollar?
To the dollar.
To the US dollar,
To
right?
the dollar, yeah.
To the US dollar.
It's the EC dollar.
I'm so sorry, can I take it?
Yes.
To the pound, yeah. The Eastern Caribbean dollar to the pound.
To the pound.
Right. Right, thank you.
What is the value? I mean, it's developed now.
It's in the statement of facts of issues, I think it's been valued at 1,133,000 east.
What I meant was that the reason it's got such a big value
Yes.
is presumably, because it's developed value, presumably that has something to do with the road which your client started to construct on the property in late 2004.
I should say that that's not happened. That was an arrangement which is no longer going ahead.
Not,
No.
I mean, am
Yeah.
I right that it's now actually,
It's got potential.
it's got potential
Yes.
for building?
Yeah.
Well, which did it have it in 1999?
I don't believe that anything's changed.
Because there's quite a big difference between the 26,000 purchase price,
Yeah.
which your client seems to have acquired the land for, and what's now said to be a land worth 1.3 million.
Yeah, so she was a distant relative of the deceased, and it may well be that they came to an arrangement that that was the appropriate price at which she was willing to give it to her for. I don't know whether it represents market value or not.
Doesn't look like it.
No. But going back to the chronology and my Lord Mance's question as to the background of the proceedings, the claim was, notice to quit was served in October 1999, and then nothing happened until January 2006, when the respondents issued proceedings in the High Court.
Yes, but I mean, he'd already said in January 2005 that when there was this problem about the road, that Mr. Henry's legal interest in the property is the subject of legal proceedings to be filed.
Indeed,
So
indeed.
it was a bit slow in
Yeah.
have them in mind.
Yeah.
And then there's a further notice to quit, isn't there, or something like it, on page 272. There's an assertion in the fourth paragraph that in 1999, Mr. Henry was given legal notification on 2 separate occasions to vacate the property by a judge. We haven't seen anything of that.
No. No. There was indeed, and it's not referred to. The February 2005 notice to quit isn't referred to in the chronology.
Well, where do we go from here then? We've looked fairly thoroughly at the judgments and
Yes.
the facts so far as we've got.
Well, my lord, I'm in your lordship's hand. You've got my statement of case, which is, it sets out the law in detail.
Yes.
My submission, as you're well aware, is that there is a finding of fact that the judge was entitled to make. It may well be helpful to your lordships to, if I can invite your attention to Datec Electronics and its judgment of my Lord Mance as to the approach in the appellate court to a finding. And inferences made of fact by a judge at first instance.
Is this a familiar point that the judge had the advantage of seeing the witnesses?
Exactly, exactly. Yes. I mean, what we say about that is you're plainly entitled to reconsider for yourselves the findings, but we would ask you to bear in mind, first of all, the important reluctance to interfere with the findings of a judge at first instance, and also to bear in mind the basis upon which the Court of Appeal overturned the decision, notwithstanding the submission that there was the weight of evidence was against the finding, was that the judge erred in law, and the Court of Appeal didn't interfere with the findings made by the judge as to the advantages. 2 final submissions. We would say, whilst scanty, the judge's approach is reasonably clear. He explains his reasons for coming to his conclusions, and there's no indication that he overlooked evidence, and that the evidence does support his conclusions. The conclusion he reached did not fall outside what was reasonably open to him to find. The fact that a different judge sitting on a different day may have formed a slightly different view or have placed more emphasis on certain aspects of the evidence than others is not a basis for interference, particularly in circumstances where one needs to bear in mind that he heard the witnesses, he heard how the evidence came across, and he was able to form a view as to the credibility of their evidence. And then finally, you have my submission about the fact that an advantage is context-specific. And here the judge plainly considered that living rent-free and feeding the family from the land plus sale of certain profits was a substantial advantage. Lord, I think that takes me on to the second submission in my outline, which deals with unconscionability.
Yes.
We've touched upon this, so unless your lordships want me to, I don't propose to take too much time over this. But it's seen as a separate overarching component and therefore needs to be satisfied. The mere fact that the deceased didn't keep her promise is not in legal terms unconscionable, and powerful support for that can be found in Cobb, where the behaviour was described as unattractive but not unconscionable, and also in the Commonwealth and Fairhaven case, which is at tab 19 of Bundle 2, where the conduct was described as morally reprehensible but not unconscionable. So the breaking of a promise is not enough. As we said, it has not expressly been dealt with, but there are 3 hurdles that need to be overcome. First, it would need to be established that the detriment was sufficiently substantial to make it unconscionable for the promise to be reneged upon. Second of all...
Sorry, can you just say that again?
There are 3 hurdles we would submit that would need to be overcome. The first one is that one needs to consider the extent of the detriment.
Yeah.
The second is concerns the position of the first appellant. and the interests and respective prejudices to the respondent and the first appellant would need to be borne in mind by the court. And thirdly, the court can take into account the position of the second appellant, bearing in mind that this is an undivided half share and that any equity would necessarily impinge upon the interests of the second appellant. Those are the submissions we make in our written case, and I repeat them in oral submissions.
Yeah.
My Lords, if I may now then turn to the second category of submissions, which only arises if the appeal fails on the first, and your Lordships are satisfied that an equity has arisen by virtue of the doctrine of proprietary stopping. That then takes us to the question of relief. Again, I don't understand there to be much between my learned friend and I as to the relevant principles. The Court of Appeal, look at their judgment again, at 243.
At what?
243, my Lord. They correctly identified that once the equity is established, the next exercise was to determine its extent. And then they singularly failed to do that on the basis that they considered there wasn't any power in the court to consider the issue of proportionality. They simply applied the expectation measure without further ado. My Lord, that's clearly wrong and inconsistent with Jennings and Rice. It's at Bundle 2, tab 26. And it's really, you can get this from the head note, but there are a number of extracts throughout that judgment. If I can just invite your Lordship's attention to the head note.
So we're back to looking at all the circumstances again.
Yeah, that's after due justice, exactly. Yeah. But he says the most essential requirement is that there must be proportionality between the expectation and the detriment. So detriment again comes in, and the extent of the detriment.
Sorry, which paragraph?
It's the head note, my Lord, behind tab 26.
Yeah.
He considers that proportionality is the most essential requirement, and it's proportionality between the expectation and the detriment. Yeah. And then, about four lines from the bottom, he says, if I can just take you through the whole of the head note, category of case where mutual understanding, which is reasonably clear, doesn't amount to a contract. The natural response is to fulfill expectations. But if the expectations are uncertain or extravagant or out of all proportion of the detriment which has been suffered, the court can and should recognise, should be satisfied in another and generally more limited way. Should not in such a case abandon expectations completely and simply look to the detriment suffered as defining the appropriate measure. Why judgmental discretion?
So what happened there was that the judge awarded some sums of money.
Yes.
And the argument was that he should have had the whole estate,
Yes.
I think, wasn't it? And that was rejected on appeal.
Yes, he awarded £200,000, and that was measured on the basis of what it would have cost for a full-time carer. As opposed to the whole estate. And that's consistent with the approach in Campbell and Griffin, which I refer to in my case, which is also a carer's case. Campbell and Griffin is in the same bundle at tab 25. And you'll see from that case that paragraph 2, judgment of Justice Robert Walker, Mr. Campbell had lived in the property and he cared for the Ascos over a long period as the couple became increasingly frail. He was a lodger, effectively. There was no relation between the parties.
I'm not sure we get terribly much out of these cases because the facts are always going to
differ
very much, and the broad principle is clear enough.
Yeah.
But in this case, what we have is the Court of Appeal, without any discussion apparently, looking at the terms of the order, just saying that he's declared to be the owner of the undivided half interest.
Indeed.
And there's no indication that they actually assessed whether that bore in any proportionate way to the detriment.
No. But the reason we refer and rely on this case is in support of our first submission that the equity, in this case we say, has been satisfied as a result of benefits. Sledmore and Dalby was a case where the court was of the view that the equity had been satisfied. In Campbell and Griffin, it hadn't been satisfied, but a rather very, very much lesser award was granted in that case. And whilst fact specific, I'd ask your lordships to bear in mind that there was no question in Campbell and Griffin of any profiting of the land, of any living being made off the land, as there was in this case.
Is it part of your case that if you're looking at the benefits, the fact is that he's remained in the property for 10 years since the critical date, rent-free?
Yeah, it continues to be
So
there.
one takes account of the continuing elements since the date of death, doesn't one?
Absolutely. Yes. Not only do we say that this case throws into sharp relief the disproportionality of the award by the Court of Appeal, but it also supports rather than undermines our primary position that no award, no relief should be granted in the circumstances of this case.
Well, supposing we were against you on up until this stage, what relief, supposing we felt that some form of relief was necessary or appropriate and indeed proportionate, what do you suggest? Do you have any sort of halfway house on this point?
Given that it's a matter that the court has to consider in the balance having regard to all the circumstances, one approach may well be to remit the matter back to the trial judge.
To do what?
To remit the matter back to the trial judge.
I think we're usually quite reluctant to do that unless driven to it, particularly in the view of the time it's taken to bring the matter before us. It's better to be resolved if we can.
Yes. But the concern that we had is, suggesting for a moment, and we're often ready, the approach should be adopted, but it's obviously of singular importance to the parties that the relief should be the appropriate and right relief, and based on all relevant factors. Now, given that neither the trial judge nor the Court of Appeal expressly considered this issue,
there doesn't seem to be much debate before either on this point.
No.
I mean, I was looking at the written submissions. There doesn't seem to be much consideration of it before.
No.
It'd be a complete guess. I mean, supposing we took the view that on the face of it, he's living in a house and he's been there a long time, and it would be disproportionate that he should actually lose the house, but the rest of the property is a different matter. 8 acres is a pretty large area of land. But one hasn't a clue what the value is or how you would satisfy that as an equity. I mean, it would be a complete guess.
There would need to be an inquiry, and whilst I accept the reluctance of refer it and for there to be further stages in the process, the concern would be that if one doesn't do that, then one is forming a conclusion based on insufficient material. But, my lords, as you know...
We don't know where the house is on the property. We don't know what the development prospects of the property are. We don't know anything about it at all. We don't know how much of it is undevelopable mountainside. We don't know anything. Really.
No. But as your lordships know, our starting point is that given the the lengthy period of time and the advantages, that it would not be... this is a Sledmore and Dalby case, and there's no reason why the relief should be, any relief should be granted. As I say in my case, the maximum extent of the equity would be a small monetary payment. I'm not in a position to tell your lordships what that should be.
I suppose I'm just thinking of the question of what sort of form any remedy might take rather than the size of it, as it were. I suppose it would be theoretically possible to grant an undivided share less than a half.
No.
Or in Jennings and Rice, it was measured on the basis of the care that had been given. So an active detriment was that he had cared and his girlfriend.
But forgive me, I wasn't at the moment asking you to comment on the size of it. But it would be possible to give him award him an undivided share. It would be possible to say that he could remain in occupation until sale of the land. And it would also be possible, I suppose, to direct that on a sale, he gets not an undivided share, but a specific sum of money charged on the share of the first appellant. I mean, those are possibilities, I
There
suppose.
are almost limitless possibility. The court has a wide discretion and can award a monetary payment, and can award an interest, can award a life interest in certain parts of the property. But the difficulty I have in suggesting something, and your lordships will have in coming up with something, I suspect, is that we don't know enough about the property to know whether or not one or other of the possibilities is achievable.
We couldn't award a life interest, could we, although you are acting for both, which affected the right of the other half owner to have this property sold at any time, or like a partition?
My lord, when I referred to life, I was talking more generally about the options that would be open to a court in a proprietary estoppel case. I don't suggest that that's appropriate in this particular case.
Is that a problem, isn't it?
Yeah.
It may be an unreal problem.
Yes.
I used to thought, I mean, we either cut the Gordian knot by saying, I mean, assuming we were to find some, but not the whole of the first appellant's interest should go to him, we could say, right, he can have a third of her interest. In other words, he has 1/6, she has 1/3 of the joint interest, and not to be dispossessed until any question of partition and sale and all the rest of it's been achieved.
Yeah, the problem with that, I suppose, is that paves the way to further litigation, no doubt, because he's the only one in occupation of it.
What further litigation?
There may be disputes, I know not, but about whether or not the property should be sold from time. He might want to be there and might dispute any application for an order for sale, for example. I'm just speculating as to what the future might hold. But so long as he remains there, it's clear that he's in occupation of the land and has been with his family, and he would not want to be supplanted. Presumably, he would say it's not fair to sell the property in circumstances where I live there with my children.
Well, I'm not sure we can probe this very much further. Obviously, there are all sorts of possibilities,
Yes.
and it'd probably better to hear from Mr. Foster a little more, give us some more facts if there are any available. Is there anything more you'd like to say at this stage? Or
No,
we obviously have to reply in due course. Thank you very much indeed. Yes, Mr. Foster.
This is the problem.
Now, there is a lectern here which can be moved sideways, I think, if you'd like to take it across. Are you happy to speak from where you are?
Oh, I'm so sorry.
Well, because my authority is here, I think
It's a rather big lectern, I'm sorry.
Oh, so, thanks.
Okay. It's not the ideal.
Not ideal, but
Yes, it is.
Good morning, my lords. I think I've said good morning, and I'd like to do so. My lords, I'd like to address the respondent's case by looking at the issues which were raised by my learned friend in her case, and then in the order that she did so, my lords. And then I would like to say something as well about, at the end, the question of the unconscionability and the aspect of the minimum and maximum equity, and the arguments by my learned friend about the interpretation of Jennings and Rice on the proportionality. My lords, on the appellant's case, sir. My Lord, the first issue which was advanced by my learned friend was whether the Court of Appeal was right to hold that the trial judge had misapplied the law in his approach to the question of detriment. On this issue, my Lords, it is the respondent's case that the Court of Appeal was right to hold that the trial judge misapplied the law in his approach to the question of detriment. The learned judge applied the wrong legal test that is respectfully submitted on detrimental reliance, both on the facts and on the law. It is my respectful submission, my Lords, that the legal test on detrimental reliance has evolved to include circumstances where a party who has been given assurances acts on the face of it in such circumstances that it would be unjust and inequitable for the party making the assurance to go back on it. It is therefore the respondent's case that that is exactly what happened in the matter of the relationship between Geraldine Pierre, the deceased, and the respondent, Calixtus Henry. My Lord, we are looking at a relationship that spans for over a solid and concrete relationship between the parties that go back certainly for 25 years.
Well, how can you decide what's unjust without comparing advantages with detriment, or without considering whether the benefit received has been disproportionate to the detriment?
Yes. My Lord, I believe that that point, we have to look at what were specific promises here, which were unambiguous, crystal clear, unequivocal. Geraldine Pierre advanced for 25 years.
No, answer the question, though. I mean, you say the Court of Appeal was wrong in law. The Court of Appeal said...
No, the trial judgment.
Sorry, you said the Court of Appeal was right in law.
Yes.
The Court of Appeal said that there was no power to compare advantages with detriment. Where is the authority for the proposition that there's no power, and how can justice be done if you can't compare advantages with disadvantages, if you only look at one side of the equation?
No, my Lord, I certainly believe that is an issue to take into account.
Well, then the Court of Appeal was wrong, because it said there was no power to take it into account.
But I believe what the Court of Appeal was saying, my Lord, is that because the promise was specific, and also because the interest was recognizable and certain, that is the undivided one-half share, and because on the evidence it was established that the respondent had relied on the promise, i.e. that he had fulfilled the conditions of the promise, because Justice Gordon was very specific when he said that the respondent had fulfilled the conditions of caring for the deceased, which was over a period of 25 years, and also for working and cultivating and toiling the land. There was no question, and we have to remember, my Lords, that the trial judge upheld the fact that there was a promise and upheld the fact that there was indeed reliance by the respondent. These are primary facts.
When you said, though, the Court of Appeal was right to hold that the judge applied the wrong test, what sentence are you referring to in the judgment? Are you referring to the first sentence of paragraph 11 of the Court of Appeal's judgment?
Well, Lord,
we're not I mean, the promise point, the promise element in this story is not really in dispute. There's a good finding in your favour on that.
Yeah.
But I don't think the Court of Appeal are in any way taking away anything from the promise. Yeah. But am I right that your argument is directed to the first sentence of paragraph 11?
Yes. But, my Lord, where we say that I find, where Justice Gordon says that I find that the appellant did suffer detriment in reliance on that promise, yes. Geraldine Pierre made it clear that the promise of the land was conditional. And conditional on the continued working of the land. There is no doubt that the appellant continued not only to work the land, but to look after Geraldine Pierre. It was evidence that he always took food from Mrs. Pierre.
Yes. Well, I don't think there's any dispute on those sentences with what the trial judge was talking about. It's the beginning of the paragraph that's the important bit. And are you saying, you're saying that the Court of Appeal were right to criticise the judge, are you, for comparing the advantage with the detriment?
Yes, my lord, under the circumstances, because I believe even the authority in Jennings and Rice qualifies the, I believe the issue is always, my lords, that once an estoppel is raised, that it's the courts do justice.
Yes.
That is the essential principle.
So
the cases do show.
Just to sort of understand it, you're saying that you're not suggesting that there can never be a case where it would be right to look at the disadvantage, but you're saying, are you, that in this case, given the nature of the promise and what actually happened,
Absolutely,
it really doesn't take you anywhere to consider disadvantages, or sorry, advantages against the disadvantage.
Yes,
Yes.
my lord, thanks for the correction on that point. Yes, I believe that this is one of the cases where the maximum equity, where because of the circumstances surrounding the relationship between the parties, where the court is right to grant the undivided 1/2 share of the entire 1/2 share of the deceased property to Mr. Calixtus Henry, my lords. My lords, my learned friend had made issue that the Court of Appeal interfered with the learned trial judge's approach, that the trial judge had misapplied the law in his approach to the question of detriment. This is what I would like to suggest that the Court of Appeal, in fact, did not misapply the law, and that the Court of Appeal took the correct approach. My lords, in the case of Greasley and Cook, 1980, 3 All England, page 7110, facts could be summarized, where it says, a caring for a family by an individual who was promised that in so doing she would be able to live in the house for as long as she wished, was considered sufficient detriment, or considered sufficient to raise the equity in the carer's favor, enabling her to raise an estoppel to grant her the relief promised. And in the case of Inwards and Baker, 1965, again, Lord Denham, and also the case of Pascoe and Turner, it was the reliance on the assurance of the promise by virtue of expenditure of money on the property which raised detriment and which provided the estoppel. Here it is the prejudice suffered by the expenditure of money which expressed or amplified the detriment. Again, my lords, the Privy Council case, and forgive my pronunciation, my lords, of Lin Tang Hing and Su Chang, Privy Council, 1992. There's also example of expenditure of money as an act showing reliance on a promise which amounted to detriment. Accordingly, the legal test of detrimental reliance relates to those circumstances where the representee is left unconscionably disadvantaged by its reliance on the relevant assurances of entitlement. An example, my lords, of expenditure of care, which was sufficient over a period of time to raise the issue of detriment, was found in Rebasham, 1986, One Weekly Law Report. Here, the promisor was estopped because the promisee had changed her position by her actions which showed that she had completely relied on the promisor's assurance. My lords, analysis...
I mean, how do you show that the respondent did change his position here? I mean, what are you saying was the expenditure? I mean, have we got any findings of fact beyond such as we see at page 217 in the judge's setting out the background that we looked at earlier, namely that your client's grandmother was allowed to put a wooden house up there, and there it is, he lived there ever since. I mean, where's the expenditure of money by him?
Yes.
How do we know that he expended any money at all? I mean, he merely used the house and used the land.
Yeah. My Lord, as Lord Denon said in Greasley and Cook, and which I believe that it is not so much just the aspect of the expenditure of money that raises the issue of detriment, but in this particular case, my Lord, to answer the question directly, there is no evidence of exactly how much he spent, but his witness statement and the evidence in the case, both of the second appellant, that's the witness statement of the second appellant, agrees that the second appellant's position is that he had occupied a wooden house which he repaired and which he renovated. His statement is clear that because of the promise, he had built a house on his land for the family, for his family. And my Lord, whilst there is no extension, you have to understand the culture of our society. This is not, for instance, as in the Gillette and Holt position, where I was looking at the advantages and disadvantages, and we saw a whole list of expenditures and accounts being thrown in. This is not the position in St. Lucia. We're looking at 25 years ago. We look at a very undeveloped society in that respect, my Lord, and very rural. The issue here is that the witness statement of Calixtus Henry is uncontroverted, that he expended money or the energy on building materials to build his house for his family. I think that is a crucial point. In addition to that...
Is that the same or a different house?
Yeah, well, but Lord, you see, the issue is that the little judge, we believe, fell into error. There's absolutely no ground on which he could base his judgment or his ruling that the respondent had lived at his grandmother up until the date of his judgment. It is not supported at all anywhere in the trial at all.
So what is the position? You're saying that you're supporting paragraph 17 on page 12, are
Yes.
you? That he, at some stage, which isn't identified, he built a house for his family, whereas previously he'd been living in the wooden house with his grandmother.
That's right. Yes.
And you're saying, well, it's fairly obvious he couldn't support his family in the wooden house that his grandmother built. So there's been something else done. And am I right that you're saying that given the society in which he is living, much of this would be his own work,
Yes.
putting up the house? He gets materials in, it's his own time and labour and all the rest of it. He puts it up, and there he is.
Absolutely not. That actually is correct.
Are we told when his grandmother died?
Yes, in
My Lord,
1988.
she seems to
October
have passed
1999.
away at about when he was 15 years old.
What?
When he was about 15 years old.
Well, where when he was about 15, so that would be way back, what?
About 25 years.
So in the
That's all.
70s, is it?
Yes, there's no clear date when his grandmother died, but I believe it's
Well,
accepted.
what happened to the wooden, wait a minute.
Sorry, my Lord?
What then happened to the wooden house?
My Lord, the evidence is that he built his own house. The issue about, in fact, what is interesting in this case is that the judge made this presumption of him living in his grandmother's house, when indeed and in fact, the evidence of the appellants in this matter is that that Gladys Henry was his mother, not his grandmother. And that's in the evidence, my Lord. You see, my Lord, a close scrutiny of the trial betrays the fact that the learned trial judge got primary facts wrong in this case. We believe that he got the crucial primary facts on the promise and the crucial primary facts established on the reliance.
But wait a minute, the Court of Appeal must have got them completely wrong too, as well. I mean, if you look at page 238, paragraph 2, during her lifetime, she permitted the grandmother to put a wooden house on the land where she lived with the appellant for some 30 or 40 years until her death. The appellant continues to live on the land until now.
I believe, my lords, that what occurred here is that the Court of Appeal had read the judgment of Justice Cottle. But, as I said, close scrutiny, in fact, of what actually transpired at trial.
But I mean, did you
Well, my lord,
raise this point with the Court of Appeal?
well, my lord, this is quite interesting because in attendance at the Court of Appeal, I was asked that I didn't have to say anything. I was asked to make no comments. My learned friend Mr. Alcid is here to support me on this issue, and the Court of Appeal were interested in trying to determine why it was that the judge, the learned judge, at trial, could determine reliance, and therefore the conditions that related to reliance, expenditure of care, labor, remaining in St. Lucia at the request of the deceased, because the evidence against shows that all of the deceased family had made this exodus out of the land and out to St. Lucia. And it was only the respondent who remained loyal and remained with her. Not only did he remain with her, my lords, his entire life was interwoven and connected with her. It wasn't just a question, as the learned trial judge put it, of a person living on land which he was born on. That's we say not supported by the primary facts or the evidence in the case. The evidence shows a complete system of care for an elderly person in a country without a national health service, where growing old is a matter of concern. As one gets disabled, as one gets older, and the system of care which the respondent put into ensuring the welfare of Geraldine Pierre. There was a quasi-shift system where his common-law wife, Gabriella Williams, and his children also attended to the needs of Geraldine Pierre. Lord, if I can take you to the position in this case, we have the land of Jalousie, which for Geraldine Pierre was of extreme importance, was her life. She wanted to remain in her own country and die in her own country. That is supported by the appellant's statement, who, in the evidence, indicate that they tried in vain to get her to come to St. Croix on a holiday, and she refused to go. It is only the respondent who remained committed to the deceased in this matter.
Can we just go back to the house? I see that there is some countervailing evidence. If you look at page 25, Mary Ann Mitchell,
yes, Lord.
Paragraph 9,
Yes.
The house which the claimant claimed he built was always there. The claimant may have carried out repairs and renovation to the said wooden house, but the structure was always there.
Yeah.
So the judge was entitled to, wasn't he, to make a finding, having heard all the evidence, that the house your client is living in is the same house he lived in with his grandmother.
No, my lord, I see why I believe that the learned judge was not entitled to that in first, because the statement, if you look back at the statement of Mitchell, in fact, it contradicts the trial judge's view that he remained on the land rent-free for decades. When you look at paragraph 4 of the second appellant's statement, what she says in paragraph 1, that is page 24 of the record, when the claimant's mother passed away, the claimant was living with his grandmother. As far as I'm aware, the claimant never lived on the said land in Geraldine Pierre.
Well, you don't suggest she did, because we know that Geraldine Pierre lived elsewhere.
Well,
and his case was, in evidence, that he went to see her, and his wife got up very early in the morning and went to see her.
Yes, my lord, that is correct. But the issue here is that she speaks of the claimant's mother died. It was his neighbor, Gabriel, who had the land. The claimant later came to live with Gabriel Alexander land and eventually forced Gabriel Alexander out of the land. So she suggested, my lords, that even the respondent was not there at one point, that he sort of came back
there wasn't any evidence about this at all, was there? No cross-examination?
No, but it was in the witness statement. There was no, the issue of cross-examination and in the trial was specific around the questions of expenditure of labor and care. In other words, to raise the estoppel and the fact that there was a promise which was specific and unambiguous in this case.
It appears to me that it amounts really to this. It seems to be common ground that the grandmother was allowed to live on the deceased's land, and moreover, he went to live there at some fairly early date with the grandmother, with his grandmother.
No,
Is that right?
The evidence is, my lord, that he was...
Well, can I just indicate what appears to me at the moment to be the position? And that during the time he was there, he worked the land, he also worked in a bakery, he sometimes used the produce of the land to eat, he sometimes gave it to his grandmother, and no doubt he sometimes sold some. But after his grandmother died, there seems to be some confusion as to whether he built himself a new house or whether he in some way converted the grandmother's house. Whether it really makes very much difference in the great scheme of things, which of those it is, I don't know. But he carried on living there with his family. And critically, on your case at least, he looked after in a real way his grandmother, who he described as Mama throughout his life, through much of that period. Yes. When at a time...
His great aunt. His great aunt.
His great aunt, I'm sorry, his great aunt. Throughout much of that period, while the other relatives were leaving, leaving Lucia and going off to England or indeed the Virgin Islands. And and the other aspect of it is the evidence of the promises that she had apparently made to him, that if he assisted her in this way, he could live on the land and it would be passed down to him and his children.
Yes, Lord.
That's really what it boils down to. The question is, and it's, you accept, though, that it is a question of balance between what might amount to detriment and what might amount to advantage in deciding whether the equity exists and indeed deciding what, if any, remedies should be granted.
Yes, my lord. In fact,
well, that's broadly speaking the position.
Absolutely, my lord. And my role, my lord, is to try to point you to the weight of the expenditure of labor and conditions and the commitment and sacrifice and the martyrdom, so to speak, of Calixtus. Because if we were to understand that he had completely beck and call, he assumed almost, he lived his life through.
Well, the judge has heard the evidence, and he hasn't formed the view that this is a case of martyrdom. And there was a lot of cross-examination. It's not really the function of this court, is it, to review the evidence in the way you're suggesting?
Yes, but what I'm saying, and I think having read my learned friend's authority and Lord Mann's on the Court of Appeal's power to review the facts, certainly in this case the Court of Appeal had access to the record and probably examined what had occurred. Certainly, the Lord Court of Appeal have got the issue on the grandmother's house. Maybe the court didn't feel that was so much significance, right? In that regard.
Sorry, Mr. President. I mean, if we look at page 263, which is the earlier of the wills, the one where he was going to be benefited. I mean, we referred this earlier, but actually this isn't the last will. The last will comes 2 pages on and is 2 years later, 1999, and then he gets nothing. But if we look at 1997, page 263, not only is he appointed the executor under paragraph 3, but he does pretty well at paragraph 4. I mean, which land are we dealing with here? Is it either of those things referred to at paragraph 4?
The land that is spoken of at Compa is in fact the land at which is on right now.
Sorry, is that the land we're talking about?
Collect my share undivided 2, and in my property situated Compa. Compa is
what we're talking about,
yes,
is it?
yes, yes.
So he was going to get that, and he was also going to get the old lady's, Geraldine's house?
Which on the evidence says it was washed away in the sea in the hurricane.
When was that?
He gave that in his evidence, my lord.
Roughly, when you remember when that?
It's not in your chronology. We believe, my lord, that where is Hurricane Allen? But we can't say, it isn't in the evidence. I can't get my hands on it at this point, but he indicates in his cross-examination that the house had been washed away. That is the dwelling house that he was promised in the will.
What page is that?
But if I were
It's
to,
page 90, at line 5. The sea, just go with the house.
Oh, yes.
thank you very much.
Yes.
So when was that?
Line 5, page 90.
No, but what date?
Oh, it doesn't say. I don't think it gives a date.
Was that before or after? It was obviously after 1997 when she made that will, but what about 1999? Does it figure at page 266?
Well, it doesn't mention.
Doesn't seem to mention. Maybe it'd been washed away by then, has it?
Yes, my lord, it was washed away.
Before 1999.
When was the hurricane?
We're trying to, we can't record.
Well, all we have is, if you look at page 266, it doesn't appear there, and she made a specific request before, and it's rather odd it's not there
Yes.
if it still existed.
Yes,
There were frequent hurricanes.
yes, but my lord, his evidence, and it wasn't pleaded that this was part of his claim.
Where did she move to when her house was washed away?
My lord, we believe that she had lived at her husband's house in Barron's Drive. We don't believe it appears on the evidence that
Yeah.
the house that she lived in until she died wasn't the house that was actually washed away. There was another property.
There are further clues. I think if you look at where she's described at page 263, it says Geraldine Pierre, widow of Baron's Drive, Soufrière.
Yes,
If you look at page 266, she's now described as of Fond Bernier in the town of Soufrière. So she's got a different address, and we don't know what the state was of the property, but she's no longer at Baron's Drive
yes.
at the time of the second will.
Well, maybe that's why she had to sell this, sell her interest to. Well, I don't know.
Anyway,
Well, perhaps that's all a red herring. All right.
Yeah. My lord, the issue in the case for the respondent was very much about committing his life. That one day he would be the owner of her estate, a jalousie, compa, and that he did everything in his power, and he carried out his task and the conditions without question. And I believe that is where the Court of Appeal had got into divergence with the trial judge, because
we're back to paragraph 11, are we?
yes,
Well, I'm not sure there's much more you can really say about that. You're saying that, all right, there could be cases where it's proper to look at advantages and so on, but you're saying that the commitment in this case was so obvious and so strong and so
Yes.
long-lasting that really the advantages disappear out of the picture.
Absolutely.
That's really your case, and you're saying, no doubt, that the Court of Appeal were quite right in paragraph 13 to draw attention to the statute and say that the trial judge had misdirected himself on that bit.
yes, absolutely. That is my case, my lords. And in addition to that, I go into quite depth in my speaking note on how I believe the Court of Appeal was right to suggest that the little trial judge had misapplied the law on detrimental reliance, and that given the fact that the respondent had carried out the conditions in the detail in which we're saying that he did, that it was within their power to see the detriment suffered. In other words, their interpretation of conditions relied on were at cross purposes with the trial judge. And my little friend says that the Court of Appeal did not make any reference to authorities, but the Court of Appeal had made reference, admittedly, to one authority in which Justice Barrow argued that the circumstances in the Calixtus Henry case were similar to the matter in...
Well, there's a very, very long quotation.
Yes, that's my lord.
But there are bits in the passage that they quote which you might say are directly relevant to what you're submitting.
Yeah, I believe the number of cases showed the expenditure of labor. They showed the specific nature of the promise being unambiguous, showed that the property was also recognizable and identifiable, and the courts, having access to the record, were of the view that it would be wholly incredulous, just wholly incredulous for the trial judge to have ruled in the way that he did.
Well, I think you're getting to the point where you're beginning to repeat your submissions. I think we have that chapter of the argument fairly clearly in mind.
My lord, I would like to say...
Suppose we were to reach these conclusions. Suppose we thought that the judge... suppose we rejected the appellant's argument that the judge was entitled to reach the conclusion he did on the basis that there's no very satisfactory evidence that he weighed the detriment against the benefit. He simply seems to have focused on the benefit without focusing very much on the other side of the coin.
Yes.
And suppose we also think that the Court of Appeal misdirected itself because it said that it was wrong to compare the advantage with the detriment,
yes,
which I think you concede was wrong in principle. So then we have both courts making errors of principle. What shall we do then?
I believe, my lord, that I agree that there was, by the Court of Appeal, a statement that runs in the face of authorities.
Yeah, well, what should we do then on that hypothesis?
My lord,
suppose they were both wrong. What should we do?
I would, it is my respectful submission that the expectation measure of the respondent be granted. And I believe that there is enough evidence in the case to establish that he was deserving of that. It is not in the line of authorities of Jennings and Rice, or in fact, his expectations and his expenditure of labor, expenditure of care, seems to fall in line with the cases around Pascoe and Turner, the Privy Council case that I had referred to, my lord, a recent Privy Council case in Lim Ting Heng and An Sri Chun. His expectations also seem to fall in line, I would say hand in glove, with that of Inwards and Baker in terms of the expenditure of care, and also that of Rebasham, my lord.
Does it really come to this that you're saying in answer to Lord Clark that there is enough in the case anyway for us to address now the issue of unconscionability?
Yes, absolutely.
Whether it can properly be said that it was unconscionable for your client to be denied what had been promised to him?
Yes, my lord.
So what is the position there? Because we have to form a view about that.
Because, my lord, after working for 25 years and the weight of 25 years of commitment, we look at Gillett and Holt, where we begin to examine the crux of the issue of where we address unconscionability. And I refer my lord to the case in Gillett and Holt, which is a...
What is the finding, though? I mean, this is not a 25-year case, is it? Because the judge has found that she was a feisty lady who was a compos mentis at the end of her life and rejected a challenge to the sale, I think. On the other hand, there is evidence that she became infirm in the last year or two of her life, which is, I mean, the suggestion might be made that that's the real focus of the care and attention that was given she was living independently by herself, and if she was pretty hale and hearty, one would expect her to be looking after herself most of the time.
My lord, you speaking of the deceased, my lord?
I'm speaking of the deceased, yes. You're comparing this to a 25-year-old case of 25 years of care, but it doesn't at the moment seem obvious that that is necessarily this case.
No, my lord, what I'm saying is that, my lord, is that there were a multiplicity of facts, a multiplicity of undertakings which were grounded in care and labor for the benefit of the deceased. And that we have to imagine him, Lord, being on the land with Geraldine Pierre throughout her life, where it was important for her to work the land for herself. So he was there to attend to her in the morning, and work the land with her, which was...
Wait a minute. I don't understand. I mean, she wasn't living on the land, was she?
No, but the evidence is that she went up to the land every day until she could no longer do so. And that he was there. And even when she couldn't be on the land, he was always there to meet her visitations. And he goes into that aspect when he, at paragraph 9 of the record, my lord, if he goes there.
Page 9?
Page 9
Yes.
of the record.
There's a description at the top of that page of the daily visits, almost every other day,
Yeah.
she visited, and what was going on to look after the goats and the chickens and so on. And so
That's
forth.
right. So it was important for Geraldine Pierre. Remember, my lords, as well, that the condition for, the little judge speaks of rent-free accommodation and benefits occurred. We believe that that's not justified on the evidence, because in fact it was a condition of the grant of land to him that he lived on the land. In other words, Geraldine Pierre wanted his presence on the land for protection and for her visitations, or for when she herself wanted to cultivate, toil the land. That was imperative. And so, in a sense, you imagine the cottager or the forester who was given a job, and that is that you must be on the land. We have to say that the learned trial judge who speaks of benefits, that is not justified on the evidence. There is nothing to suggest that the farm was, the piece of land, my lord, was of commercial concern or for business purposes in any way. And in fact, like in David Thorne or Thorne and Curtis, his help was unpaid help. And he cultivated what is 7 acres of land single-handedly, of course, just with the assistance of Geraldine Pierre. I point, my lords, as well to, sorry.
So the idea of him living there rent-free, you say, is a misconception,
Absolute
really, that
misconception.
he was expected to be there, a custodian, as it were, of the land, just to be...
Yes.
So there was always somebody there to keep people off, I dare say, or look after
Absolutely.
the animals and so on.
And which I say he was entitled to come back if you want to assume that the second appellant was correct in her evidence that, you know, he wasn't on the land. He came back and he evicted Gregory Alexander, as he was entitled to do, my lords. So, my lords, the learned trial judge, we would respectfully, it's our respectful submission of our case, completely misconstrued primary facts in this case, and completely ignored the reliance aspect which he found to exist. And this is where the Court of Appeal intervened in the case. The evidence in this case, my lord, shows that the respondent acted upon the footing of the state of affairs assumed that he would inherit the deceased's share in her land.
Yes, well, you've said that
Yes.
many times. I don't think that the promise is in dispute, so we know all of that.
Sorry. Yeah. My Lord, in looking at the question of unconscionability, where we say the aspect of unconscionability comes into focus at the time when that which was promised to him is taken away. We now see the effect of the detriment that he suffered. We look back in time and we see a commitment of 25 years. And everything that he worked for is now is up in the air.
Well, you're suggesting we look 25 years back from the date of the dispossession or the attempt to dispossess.
Yes, that's correct, my Lord. That is where the authorities say as well. We can see the change of the position, or we could understand the change of position from that point. So we look to see at that crucial point in history, what did this man do that makes the act of the disposition unconscionable? And then we see the betrayal that he suffered when that which he was promised is taken away from him, Lord. We look now to see what we can grasp onto to show that he made that commitment. And it is hard to visualize the toil and sweat, my Lord.
Well, I don't think we need to really go over this too much. I mean, we've understood your case on the commitment and all of that. And I wonder whether we're really not reaching the point where we should be looking at the relief, the equity, because one of the things that has emerged in argument today is that the Court of Appeal, having come out in your favour for the reasons we see,
Yes.
which you're asking us to support, have in the end given you the whole of the half interest
Yes.
in the land. And the
Yes.
question is that proportionate
Yes,
to what you're talking about? And
yes,
we've
my
got to
Lord.
look back at what you're saying about the commitment
Yes.
and so on to decide whether that is a fair representation of what has actually happened.
And another view of the commitment is that this was a very happy mutual arrangement, as your client said. I plant food for me to live with my family, and if it have too much when it beareth me, I sell some of it. I cannot eat it all with my family, so I have to sell some of it. That's the way I was living on the land. And then he said I was also taking food for her, always taking food for Geraldine Pierre.
Yeah.
So, I mean, this is and then he said she became infirm. Actually, I think she said about 5 years before she died. So I was wrong in saying 2.
It makes sense. It's Jan 95.
Yes. So, my Lord, if my Lord, you'd like me to go back then to the issue of the commitment and...
No, I mean, I think the point my Lord was asking was a different one.
Yes, I mean, I'm moving from the commitment to see just how that helps us on the proportionality of the remedy which the Court of Appeal have awarded. Now, that's, of course, what you were asking for.
Yes, my Lord.
But the question is whether that is
I'll
really
make
right.
reference, my Lord, to my learned friend's authority in Jenin and Rice
Yes.
to give my interpretation of that authority, my Lord.
Do you have the volume number in the tab?
So, where's it again? It's page 2. Page at 26, my Lord.
Tab 26.
My Lord, looking at the head note in this matter, the argument in Jenin and Rice, as I understand it, is that the courts did their very best to be equitable, and they did so under the constraints of there not being a specific promise, or there not being, or uncertainty around the subject matter. In fact, this is one of the cases where the courts, where they cannot determine what was actually promised and they cannot see the extent of what was promised, do their best to be equitable in the case. And I believe this is indicated here at H3, at the tab where it says, the task of the court is to do justice, to do what is necessary to avoid an unconscionable result. The most essential requirement is that there must be proportionality between the expectation and detriment. Yes, I agree. But, my Lord, I believe that is qualified when it says there is a category of case in which the benefactor and the claimant have reached a mutual understanding, which is in reasonably clear terms, but does not amount to a contract. In such a case, the court's natural response is to fulfill the claimant's expectation. But if the claimant's expectations are uncertain, or extravagant, or out of all proportion of the detriment which the claimant has suffered, the court can and should recognize the claimant's equity should be satisfied in another and generally more limited way, my lords. My lord, we are saying that what he was promised is not extravagant. And what he was promised is not uncertain. There is nothing in the respondent's case that suggests, as my learned friend tried to intimate, that the respondent will encroach on the property of the second appellant. Examination of the deed in this matter indicates that Geraldine Pierre had an undivided 1/2 interest in that land. My lord, you can see that in the exhibit of documents. The point here is, in speaking about the extravagance of the matter, this is not the case as in Jennings and Rice, where there was, in fact, quite a large estate, where the shares, which were part of the subject matter of the estate, were not even known to the Jennings. This is a very clear definition of the interest with a specific promise. Sorry. Yeah. This is a person who knew how he was able to traverse the land and farm it precisely every day. There was nothing uncertain about his understanding of her share or where her share lay, and neither was Geraldine Pierre uncertain about her own rights in the property. Unlike the case in Jennings and Rice, where Mrs. Rolls did not know the extent of her own wealth. My lords.
Yeah, so I'm looking at paragraph 50,
Yes.
actually, where Lord Walker...
Sorry?
Paragraph 50 in Jennings, where Lord Walker, this is what is repeated at the beginning of the headnote, but it's the last sentence that you're saying it shows a distinction between what he's contemplating in our case.
Yes.
You're saying this is not the kind of case that he's discussing there of uncertainty.
Absolutely. My lord, I wanted to bring this to the court's attention, but maybe the court, if I may be permitted to, and please be saying so, we should crave the indulgence of the court. This is a person who worked on land for 25 years, when 2 decades, 3 decades ago, you can buy estates of land for probably $1,000, $2,000, $3,000. He could have earned, he has benefit, he could have been elsewhere and have probably bought his own land. He was attracted to that piece of land, admittedly, but that was because Geraldine Pierre asked him, and I believe that he fulfilled that. This is a person who forgoed all of other career opportunities, any other opportunities to develop his life, to remain with her. And I believe that, my lord, I don't want to labor the point.
Is there any evidence?
But no, I believe we could take judicial notice. I look at deeds from time to time and I see...
Yeah, no, but is there any evidence about your client foregoing other forms of life or...
Well, but my lord, I believe it it's in...
No, I'm just asking whether there's any evidence about it.
The only evidence we have, my lord, is his repeated assertion that Mama promised him that if he were to remain in St. Lucia with her and work the land, he would get the land. And when we also look at other individuals leaving the land, I don't think by coincidence, happened to be the only person to have remained there. I don't think that was a fact of coincidence.
I think you're really asking us to read between the lines of what we can see on page 9. This emphasis always about remaining in St. Lucia, and you're saying, well, that makes sense in a situation where other members of the family were not disposed to remain there, and that's why she was so emphatic that she wanted him to remain and made the promise.
Yes.
You're saying this is all part and parcel of the history.
And my lord, if you can understand that inference, I believe, if we were to look at the witness statement of the second appellant, the first appellant, my lord, at page 20 of the record, paragraph 2. Paragraph 2 of the record, which is page 20, my lord.
Page 20 of the record starts at paragraph 12.
Yes, meaning paragraph 13, but paragraph 2 of page 20, my lord.
Yes.
It says...
Second paragraph.
Second paragraph.
Yes.
It says, the money I used to send to care for my aunt and daughter, when I returned home one year, she presented me with a bank book. When I told her that was not what the money was for, she told me, life is strange, you don't know you don't know how you will do. I tried in vain to send for a holiday, but she did not want to go abroad. It is clear that Geraldine Pierre wanted to be mainly rooted in St. Lucia. And the change of position is that desire rooted Calixtus Henry, rooted the respondent in St. Lucia. He wasn't just on the land, but he was at a home in Barron's Drive, looking after her and setting his family up to establish a care plan, a routine of care, and a quasi-shift system, which involved attending to her needs. In other words, in one day, or 7 days of the week, my lord.
Just getting back to your point that, about cheapness of land decades ago, paragraph 7 on page 9 of your plan suggests to me that perhaps as one would expect, the statements made by Geraldine Pierre to your client were made at some stage after some time had passed. I mean, if you look at the, it starts off by saying that the pair of relations had moved abroad, that they wanted her to go, but she wanted to stay, and she made me promise that I would help her achieve this. Because I cared for her, I was the only one who lived on and cultivated the land. And then time passed, and no other family members occupied the land or returned from some quarter to live on the land, and no other person but myself worked the land. And it was from this time on that Mama kept on repeating and saying to me that the land would belong to me if I cared for her and if I cultivated the land. And then over the page we talk about 1994. I mean, those are the sort of statements that one would expect a person to make as they were getting older and contemplating the need to be looked after. Your suggestion that it was decades before her death that your client might have gone elsewhere had you not received promises must be looked in the light of the possibility that the promises were actually made, I would suggest, on the basis of that paragraph and what follows perhaps in the early 1990s, leading up to the initial will, perhaps in 1997. What do you say to that?
My lord, the evidence also, when he was 15 years old, Geraldine Pierre was 70 years old. So it would have been appropriate for her to have made that promise to him. In addition to that, my lord...
She was 70 when he was 15?
Yes. If you look at her date of birth and look at his, you could see that when he was about 15, she was 70 years old.
She died age what?
95.
95. In addition to that, my lord, you look at paragraphs 5 and 6 on page 9, and yes, there's a full, open, and honest statement by the respondent that says that Mama at paragraph 6 gave everyone the opportunity to possess land on the mountain.
Sorry, which paragraph are you reading?
That's paragraph 6, my lord.
He did say under cross-examination at page 77
Yes.
of the bundle, she always promised me since I was a youth.
Yes, that is that, my lord. Thank you for that, because I was going to
But
come
that's
to
about
that.
all we've got
Yes.
on that point.
Yes, and that he also said, my lord, that everybody knew that she was promised him the land, that she was going to give him something. And this was from the time that he was a youth, my lord. And yet in the honor statement...
But what she promised, according to that, was she has something for me.
Yes.
Which is not quite the same as saying you would have the unconditional half share,
Yes.
not just for life, but forever.
Yes, my lord, I believe in the context of cross-examination, and we're looking at an individual who is, in St. Lucia, who is not necessarily literate. This is what he meant, my lord. I would say that we have to look at it in the context. There was vigorous cross-examination by my learned friend on the issue of the land and his entitlement to the land.
But I mean, assuming, Mr. Foster, in your favour, that, if he hadn't committed, so to speak, to the old lady and to this land and the rest of it, there's a real likelihood he would have bought his own plot. I mean, there's no reason to suppose he'd have gone and got 8 acres, is there?
Yes, my lord, I would say so. Because my point is, my lord, that, you see, Calixtus Henry's devotion should not be used against him. In the sense that it is respectfully submitted that yes, very impoverished persons, people who come from the rural community, have been able to save monies and been able to obtain quite a few acres of land, probably ranging far beyond 7 acres, depending on where they are in the community. So the issue that we have to weigh the benefits here and advantages and disadvantages, I don't believe, my lord, that it is relevant in this case. Because the devotion of Calixtus Henry, the fact that he didn't want to start off on an own adventure of his own, very much like in the facts of Thorner and Curtis, where David Thorner, this house decided in March of this year, where he had the opportunity at horse rearing. But he decided to stay with Peter Thorner and support Peter Thorner. And I believe it was Justice Lord Walker who indicated that, yes, there was a lot of emotional support and companionship, but the commitment of 29 years of devotion to Peter's farm and to...
It was a very strong case on the facts.
Yes, yes, my lord, and we believe, my lord, that the facts in fact, Thorn in Calixtus Henry is not just equal to, but probably even greater than Thorn and Curtis, because unlike Thorn and Curtis, there was no expenditure of labor or care in the way that Calixtus Henry had cared.
Now, Mr. Foster, I'm going to have to interrupt you because we're going to have to rise rather early.
Yes.
For a reason to affect some of members of the court. So would this be a convenient point at which to stop?
Yes.
And we look forward to seeing you again at 3 o'clock.
Thank you, Lord.
And to council understand, we're sitting until 4:30 if we need to. I'm not inviting you to go along as long as to 4:30, but we have a little extra time if you need it. So we'll see you at 3 o'clock and hope to finish comfortably within the remaining time.
Thank you very much.
Thank you.